So if I agree with you that we're talking about a question of law to the extent that what is at issue here is the application of the persecution standard to a known set of facts, all right? I guess what I don't understand about your argument is why the statute doesn't prescribe the standard of review in this situation. I appreciate that you say in your brief that you read C, which definitely requires deference to certain legal determinations. You say, but this is not one of them, and I guess I don't understand that. The language of C says a decision that an alien is not eligible for admission to the United States is conclusive unless manifestly contrary to the law. And in this case, I understood the agency to have determined that your client was not eligible for admission because he had not satisfied the requirements for asylum. So it seems to me to be heartland C, and therefore the statute tells us what the standard of review is supposed to be.
No, Your Honor. C is about eligibility for admission. That's a distinct inquiry for eligibility for asylum.
I don't think so. Help me to understand that. I mean, it seems to me that there are different grounds for admission, and one of them would be because you satisfied the asylum criteria, and that was what your client was trying to do. So what Congress, I think, is covering here by this broader scope of review or standard of review paragraph is all the kinds of determinations that the agency would need to make related to the eligibility for admission. This is a subset of that.
No, Justice Jackson. I mean, number one, the government has not made this argument. They've conceded that C and D do not apply. They do not capture this case.
I understand, but I'm not the government. I'm reading the statute.
Fair enough, Justice Jackson.
And my question is, why does C, it seems to me that when you look at this provision 4, it seems as though Congress was really trying to cover the waterfront of determinations that the agency makes regarding admissibility. I mean, it says, in terms of telling the courts what you're supposed to do relative to what the agency has determined. It says, look at the administrative record, only the record that was before the agency. It says all of their findings of fact are conclusive, which I agree with you, there's no finding of fact at issue here. It says their determinations about whether or not this person is eligible for admission is also conclusive unless it violates the law. That's the matter of law provision. They even go so far as to instruct the courts about the agency's determination with respect to the availability of corroborating evidence. I mean, Congress was really trying to nail it down in terms of what courts are supposed to do. So I guess I'm worried about looking at C and treating it so narrowly that we're suggesting that Congress somehow carved out asylum determinations and did not mean for everything the agency is saying regarding the determination of eligibility for admission to be included.
Yeah. So I'll start with what I agree with in what Your Honor just said, that we do think Section 1252 establishes a reticulated scheme for judicial review that was meant to be comprehensive or close to it. Where I disagree respectfully with Your Honor is that admission somehow encompasses asylum. It does not. But
don't you have then the burden, if you agree with me with the first part, of establishing that Congress intended to carve out asylum and not have it be covered by this?
Yes, I do, but I think we've shown that because, again, in D, in 1252b4d, it carves out entitlement to asylum, the second step of the asylum determination, but it doesn't say anything about the first step. And again, C, and perhaps we just disagree on this, but admission is a distinct inquiry from asylum.
Isn't that the first step? That's the first step, and then they go to the second step.
No, Your Honor, that's incorrect. You do not need to be admissible to be eligible for asylum. Those are distinct statuses. My clients have conceded removability. They've conceded they were not admissible, but they are claiming nevertheless that they are eligible for and ultimately entitled to asylum. Those are distinct inquiries. And again, I understand Your Honor is not the government, but I think that is why the government, to their credit, did not make this argument because that's well established in this court's case.